Judges may begin, and I wish you the best of luck.
Good morning. My name is Tim Isaacs. I'm Executive Director at the Center for Teaching the Rule of Law at Roanoke College in Salem, Virginia. I want to welcome you to the finals for We the People, and congratulations for making it this far. I also want to introduce my colleagues, and we will start with Darcy.
Hello, everyone. Like my colleague said, congratulations on making it. We're excited to hear from you. My name is Darcy Kern. I am a professor of history at Southern Connecticut State University.
Good morning and congratulations in making it to the national finals. My name is Jamie Gass, director of the Center for School Reform at Pioneer Institute. It's a Boston-based think tank that does research on K-12 education reform.
And if you will introduce yourselves for us, please.
Good morning. We're very excited to be with you today. My name is Abigail Anderson, and I'm a senior at East Kentwood High School.
Good morning. My name is Quinton Proctor. I'm also a senior at East Kentwood High School.
Good morning. My name is Tyler Thompson. I'm a senior at East Kentwood High School, and our coach is Mr. Justin Robbins.
Okay, this is Unit 1, and you are dealing with question 2 today. So we want to make sure we're all on the same page. I'm going to read the question and the follow-ups, and then you will begin your presentation. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it an essential part to limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Timer, you may begin.
In his 2 treatises on civil government, John Locke asserts that the people give up certain rights in order to secure liberties, and that those who violate the social contract can face further deprivation of rights. Therefore, habeas corpus is quintessential to limited government, as it allows for those who have been imprisoned to protect the right to their own bodily autonomy.
While Article 1, Section 9, Clause 2 of the Constitution secures this protection, the historical roots of habeas corpus run so deep that by the 18th century, William Blackstone referred to it as the bulwark of our liberties. In English law, Magna Carta limited government by addressing unlawful detainment in Clause 39, but did not provide a detailed process by which a detainee could sue for freedom.
In response, the Habeas Corpus Act of 1679 improved on Magna Carta's weaknesses, specifying that people had the opportunity to ask the court to determine the lawfulness of their imprisonment.
The colonial era featured rampant British abuse of habeas corpus. In the history of England, Samuel Gardiner asserts, at the time of Darnell's case, there was little doubt that the sovereign had a long exercised power of arbitrary committal, where there was thought to be a threat to the safety of the realm.
As a result, Thomas Jefferson claimed in the Declaration of Independence that the king was depriving us of the benefit of jury trial, a notion furthered by Hamilton in Federalist 84, saying that the practice of arbitrary imprisonments have been in all ages the favorite and most formidable instruments of tyranny.
Following the ratification of the Constitution, Congress authorized federal courts to grant habeas relief to federal prisoners in the Judiciary Act of 1789. Chief Justice John Marshall advanced habeas protections in Ex parte Watkins, stating that the great object of the writ of habeas corpus is liberation of those who may be imprisoned without sufficient cause.
However, controversy emerged when President Lincoln unilaterally suspended habeas corpus during the Civil War.
Following Ex parte Merriman, Lincoln explained that he intended to arrest and detain without resort to the ordinary processes individuals he might deem dangerous to the public safety in an effort to silence rebels and preserve the Union.
Lincoln's actions are supported by Locke's explanation that executive prerogative includes the power of doing public good without rule, implying an executive may step outside the framework of their authority to advance society's interests, and is backed by Hamilton in Federalist 70's argument in favor of a unitary, energetic executive.
Following the Civil War and Ex parte Milligan, the Supreme Court ruled that trials decided by military commissions were unconstitutional if civil courts are available, providing precedent for future habeas questions.
During World War II, Japanese internment under Executive Order 9066 caused an especially egregious violation of habeas corpus by an executive. as mass detentions under the premise of national security defies modern understanding of habeas.
Today, habeas questions explore the balance between limiting government to protect individual liberties while empowering it to pursue safety and order, especially in the areas of death penalty cases and suspected terrorism.
For example, in 1996, the Anti-Terrorism and Effective Death Penalty Act banned filing of successive habeas petition and restricted habeas relief to when a state court acted contrary to or an unreasonable application of clearly established federal law, lessening habeas burden on government.
The Detainee Treatment Act of 2005 and Military Commissions Act of 2006 also initially relaxed the burden on government by having Guantanamo Bay prisoners utilize military commissions and allowing the president to suspend habeas corpus for enemy combatants.
However, in Boumediene v. Bush, the Supreme Court struck down Section 7 of the Military Commissions Act, increasing habeas burden on government because the nation's basic charter cannot be contracted away and expanding territorial reach of habeas to Guantanamo Bay.
While habeas corpus can burden government in times of crisis or emergency, the lessons of history suggest its broad suspension is almost seldom justified. Habeas suspension is safest to the legislature with clearly defined aim and narrowly tailored scope.
Thank you for your time. We now welcome any questions you may have.
Okay, I'm going to begin this question. What are some other parts of the Constitution intended to protect people against arbitrary incarceration?
I believe that the due process clause is the origin that is intending to protect people from arbitrary incarceration. The habeas petition is actually what follows if the due process clause has been violated.
Adding that to Abby, habeas corpus ensures that our due process protections can be effectuated. The 4th, 5th, 6th Amendments, and even 8th and 9th all go into protecting our rights.
And following the ruling in Barron v. Baltimore, the Bill of Rights didn't initially apply to the states until after the Civil War when the 14th Amendment was passed. Through selective incorporation, these amendments did apply to the states, allowing state people indicted for state crimes to be able to file for habeas corpus petitions when their rights are denied.
Okay, thank you.
The Revolutionary and founding generations were raised as British subjects and educated under English law. Could you talk about some of the ways in which British law shaped the framers' understanding of Constitution?
So going back to Darnell's case, we had 5 knights who were arrested due to King Charles believing in divine right of the king. This opened the gateway to the Habeas Corpus Act of 1679, which greatly influenced the founders in including habeas corpus into our Constitution.
Adding on to Abby, in the Declaration of Independence, Thomas Jefferson says in the list of grievances that the British denied them the right to jury trial. He also mentions the impressment of colonists, forcing them to fight their fellow colonists in America, which is a direct infringement of their own bodily autonomy.
And a year before the Declaration of Independence, Jefferson writes the Declaration of the Causes and Necessities of Taking Up Arms, in which he mentions the meditated innovations, the statutable plunder, and the effects of acquiescence under the British Crown that spurred the cause of a revolution.
Is the government ever justified trying someone in absentia? In other words, if they're not present?
I don't believe that the government is justified if someone's not available to defend themselves. It's someone's natural right to be there to secure their own rights and liberties.
Adding on, they also have the right to seek counsel in order to ensure that their imprisonment is justified. To allow someone to be tried in absentia is to deny that basic charter that ensures our due process is being met.
According to the U.S. Constitution, only Congress has the power to suspend the writ of habeas corpus. That is, the president does not have that independent authority. Then why did prominent presidents, Lincoln, Grant, FDR, George W. Bush, why were they permitted to suspend habeas?
In regards to Lincoln, Congress wasn't in sitting when he suspended the habeas corpus or the writ of habeas corpus. So I believe that he was justified, and not only was he justified, he was acting as a virtuous leader and portraying moral prudence.
Yeah, adding on to Abby, in Federalist 70, the framers say that we need a unitary, swift, energetic executive to respond in times of crisis. And for the Lincoln suspending habeas corpus example, with Merriman, he was literally burning railroads and bridges to prevent Union troops from reinforcing the Capitol in the time of invasion. So I do believe Lincoln was justified in suspending habeas corpus.
Adding on to the moral prudence that Machiavelli proffers that Abby mentioned, Locke also mentions executive prerogative, which further justifies Lincoln's actions. However, by contrast, FDR shows a especially egregious violation of the laws of nature and of nature's God. Following the mass hysteria of the Red Scare and Pearl Harbor and interning Japanese Americans. In Common Sense, Thomas Paine says that even brutes do not devour their young, nor savages make war upon their own families. And I believe that this is an example of an executive making war upon his own family, his own American citizens, without sufficient cause. And because the court did not right this wrong in Korematsu, Congress later had to do it by issuing reparations to those who were directly affected by Executive Order 9066.
You mentioned Magna Carta in your opening, and I'm curious as to what specific, you mentioned Section 32, but what specific principle in that section has an impact on the American Constitution? And I'm not talking about habeas corpus here, but another principle that is at the heart of the American Constitution.
Clause 32 or clause 39?
39.
Okay.
And could you repeat that final part of the question, please?
Well, Magna Carta is Section 39. In fact, all Magna Carta embodies a principle that is essential to the American Constitution and to habeas corpus, for that matter, as an example. What is that principle?
I believe that the principle surrounding habeas corpus and our Constitution is protecting our own natural rights, and furthermore securing the right to a social contract, as John Locke mentions, giving up certain liberties to protect the common good.
Adding on to Abby, imprisonment denies our bodily autonomy. So while we give up certain rights in order to better protect our liberties, as Locke would mention, those who breach the social contract can see that further deprivation of rights.
Okay.
All throughout the history of our country, we see a balance between natural rights and common good. So, the balance between natural rights and common good is further by social contract theory.
Okay.
I apologize. I got so caught up. I forgot your minute.
Okay, thank you very much. I'm very pleased with the way you began, and also the fact that you weren't using any notes. That's very impressive. I was pleased to see you mention the issue of Franklin Roosevelt's 966 order and connecting that to Thomas Paine's quotation about the eating of one's own. That a lot of the connections you made had very, very solid, rational connections. So I'll pass it off to my teammates.
Yeah, I want to echo that. First of all, I want to congratulate you and your teacher and your parents for all your hard work. It's really difficult material. This is, I think, a difficult question. I think you handled it very well. I was really impressed by how you, in your introductory remarks, you had really you moved through a lot of material very quickly. Blackstone, you had a great command of and usage of quotes from the Federalist Papers. I liked how you mentioned the 1789 Judiciary Act, great use of the quote from John Marshall, as well as the sort of touchstone historical events in American history, FDR and the executive order and Gitmo and but you carried that forward, and I was impressed by how fluid it was in the Q&A. I liked your reference to the 14th Amendment. I think that may be the first time we've heard that, made that connection. And I thought that your response to my question about the various presidents was very thorough and clear, going into a lot of detail about Merriman and the railroads, and using the quote, I think, from Hamilton, Federalist 70, as well as, some line from Machiavelli and others, but it just was really well done. I in particular that question, the way you responded to that question, but you should be very pleased. It was really a strong performance this morning.
I'd echo what my colleague said. I thought this was excellent. I liked how you mentioned Darnell's case and Charles II and the English background to this. I got so excited when you talked about Machiavelli and moral prudence, because I just finished teaching Machiavelli, and prudence is his biggest virtue for the prince. So that was excellent that you guys were aware of that. This was a pleasure to listen to. My one recommendation for you as you think about this subject, and this is not a criticism, but perhaps avoid the term bodily autonomy, because I think the perception is that an individual is more than just the body, right? There's something, with the mind or whatever, that is more than just bodily autonomy. I think it's the whole individual that is encompassed by our due process, our judicial rights. So that's just a technicality, but I feel like I can say that to you guys because you are so sophisticated in thinking about this issue. So very well done. Congratulations.
Thank you.
Thank you.